Good afternoon to all. Before we start this afternoon's lecture, may I just mention a few acknowledgements. I would like to acknowledge the people who are behind this PALS Live lecture for this year. We want everybody to know this because, well, they have worked tirelessly to bring all these lectures to your homes, especially in these uncertain times. May I take this opportunity to acknowledge the President of the Philippine Association of Law Schools, Dean Mary Anineas of the Universidad de Manila College of Law, for spearheading this PALS Live lecture. This is her brainchild, and she suggested it to all the deans of the Philippine Association of Law Schools, especially the Board of Trustees. And we owe this opportunity to continue our learning to her leadership as President of the Philippine Association of Law Schools. May I also take this opportunity to thank and to acknowledge the efforts, the tireless efforts of Dean Al-Shuaid Ismael of the University of Cebu College of Law, as well as Dean Rosan Gonzaga of the University of St. La Salle College of Law. They are the co-chairpersons of the Committee on Special Interests and Special Concerns of the Philippine Association of Law Schools. And it is through their technical expertise and their efforts at marketing this regular feature since 2 weeks ago. Their efforts here are well appreciated by all your deans, all your law professors are constantly thinking about you, especially in these times. It is not only a national emergency, concerns. And for this, I would like to acknowledge the efforts of our fellow deans and the Board of Trustees of the Philippine Association of Law Schools for giving their time to this worthwhile event. Once again, good afternoon to all. Our lecture for today involves the Constitution in times of national emergency. We live in turbulent times. It is in these times when certain responses must be made, especially by our governmental authorities. Even in times of national emergency, even in turbulent times, the Constitution remains operative. The challenge that we face when it comes to living by the principles of constitutionalism is to strike a balance, a delicate balance between the liberty and security provisions of the Constitution. I would like to call this as somewhat of balancing the constitutional tightrope between the Constitution and the constitution of government. Likewise, this lecture attempts to put some sense out of a seemingly chaotic situation. But we will weather this storm. We are all into this together, and this is the time to be divided. This is rather the time to be united. But in that spirit of unity, we need to balance the needs of liberty and security as embodied in our Constitution. Now, the first question on your mind, on all our minds, is what is a national emergency? A national emergency is an emergency that notes the existence of certain conditions, national in scope and magnitude, suddenly intensifying existing danger to life as well as the security of the state. A national emergency would coincide with situations and the nation may be at peril. The life, the security of the nation is at peril. Beyond the degree of what we normally do. In other words, in an emergency, our normal lives are disrupted. So this disruption from our normal way of life calls for extraordinary measures. And these extraordinary measures in times of national emergency are the emergency powers that are reposed in ours and delegated our president, who is the chief executive of the Republic of the Philippines. As contemplated by the Constitution, the Supreme Court said that these emergency conditions may include rebellion, invasion, lawless violence, economic crisis, pestilence, or pandemics, typhoons, floods, and other natural disasters, and other similar types of catastrophic events of nationwide proportions or effect. Now, in a national emergency, as perceived by our legislature or our chief executive, is occasioned by a wide range of situations, which may be classified into three principal kinds. First involves an economic emergency. Second involves a natural disaster emergency. And third involves national security. Now, we will, as the discussion goes on, we will have a categorization of national emergencies. And I would like everyone to pay close attention to it. It's important that we are able to characterize the national emergency that has arisen in order to come out with the appropriate solutions to resolving and ending that national emergency. From a constitutional standpoint, a national emergency is a crisis of national proportions that threatens the peace, good order, security, and safety of a nation. A national emergency requires a swift and decisive response to meet the exigencies of the moment. Now, you may ask, which branch of government does the Constitution repose emergency powers? Or which branch of government is the repository of emergency powers? Clearly, Congress is authorized by the Constitution to delegate such emergency powers to the president. This is the constitutional basis of a national emergency, which is laid down in Article 6, Section 23, Paragraph 2 of the Constitution. Under what conditions can emergency powers be exercised? The following conditions must concur to warrant the exercise of emergency powers under Article 23, Paragraph 2 of the Constitution. There must be war or other national emergency. Second, Congress must authorize the president to exercise emergency powers for a limited period. Third, the authority granted to the president to exercise emergency powers must be subject to the restrictions prescribed by the Constitution. The powers must be necessary and proper to meet the existing emergency. And finally, these emergency powers must be exercised to carry out a declared national policy. Under David versus Arroyo, there were only 4 requisites that were contained therein. But for purposes of this lecture and for purposes of understanding fully the conditions by which emergency powers can be invoked, it should contain at least one more condition. David versus Arroyo only provided for 4. In this discussion, we provided for a 5th condition. The powers must be necessary and proper to meet the existing emergency. What are the powers exercised by the president in times of national emergency? The president, under Article 7 of the Constitution, exercises executive power. Under Article 7, Section 1, the executive power is vested in the President of the Republic of the Philippines. However, the powers provided for under Article 7 are the regular or ordinary powers that are given, or the X powers that are given President times of peace, in times of stability. However, there are certain powers that are delegated by Congress to the president that are emergency powers that are necessary and proper to meet the existing emergency. Now, the executive power of the president is in Article 7 includes the power of appointment, the regular powers, the ordinary powers of the president include the power of appointment, the power of general supervision over local government units, the power of control over the agencies, bureaus, and offices under the executive department, the commander-in-chief powers, which are express powers provided for under Article 7, Section 18, and the powers by necessary implication from these express or ordinary powers of the president. With respect to national emergency powers, we cannot overemphasize the importance of Congress in delegating its legislative power to the president to meet the exigencies of the time. Now let's go to let's discuss the constitutional history of national emergencies. In our discussion, we are looking at the use of national emergency powers from the 1940s to the present. Now, in the 1940s, in 1944, you would have a declaration of martial law by President Jose P. Laurel then during the Japanese occupation of the Philippines. The declaration included, the declaration of a state of martial law included as well the suspension of the privilege of the writ of habeas corpus. In 1949, President Quirino, Elpidio Quirino, suspended the privilege of the writ, the privilege of the writ of habeas corpus in some parts of Luzon to quell the rebellion of the Hukbalahap guerrillas. Commonwealth Act number 671, which was known as the Emergency Powers Act, was passed by Congress, declaring a state of total emergency. Commonwealth Act number 671 was enacted before the war. And so for the duration of the war, there was a state of total emergency by the government in exile, led by President Quezon and Vice President Osmeña. So a state of total emergency as a result of the Second World War was declared and authorized the president then, President Quezon, to promulgate rules and regulations to meet the emergency. Later on, during the Japanese occupation, um, um, the president, during the Japanese occupation, President Jose P. Laurel declared martial law to restore order in the Philippines. And well, with the impending invasion of Allied forces, martial law was declared to to um, to protect law and order. Now, in 1971, President Marcos suspended the writ of the privilege of the writ of habeas corpus in the entire country in the aftermath of the um, Plaza Miranda bombing. After which, a proclamation was made declaring martial law 1 year after. So the privilege of the writ of habeas corpus was suspended in August 21st, 1971. 1 year later, in September 23, 1972, martial law was declared in the entire Philippines. In 1989, the aftermath of the 1989 coup attempt against the administration of President Corazon Aquino, President Aquino, a few days later, about a week later, the coup attempt started. The coup attempt was launched on December 1st, and President Aquino made a proclamation declaring a state of emergency. After which, 2 weeks later, Congress passed Republic Act 6826, granting emergency powers to the president. In 1993, Congress passed Republic Act number 7648 by declaring a national emergency due to the electric power crisis prevalent in the Philippines at the time. And this was eventually signed by President Fidel V. Ramos. President Ramos certified as urgent the Electric Power Crisis Act to be able to meet that emergency, that economic during the time of President Arroyo. As well as in 2000 state of emergency due to uh, (2006). Situation, therefore, she declared a state of emergency with some alleged military. 2009, state of emergency in certain provinces in preventing and suppressing lawless forms. declared a state of martial law in the province of Maguindanao. She likewise suspended the privilege of the writ of habeas corpus therein. Now, in recent times, in 2017, times which we are more familiar with because they are of recent vintage, President Rodrigo Duterte proclaimed a state of martial law and suspended the privilege of the writ of habeas corpus in Mindanao due to incidents involving the ISIS siege of Marawi. In 2018, 2018, martial law was extended a year later. Now, for the present time, well, Presidential Proclamation number 922, which was issued earlier this year, proclaimed a state of public health emergency, in which Republic Act 11332 was rendered operative to meet that public health emergency. A few days later, a state of calamity was proclaimed. Subsequently, after these two presidential proclamations, Congress enacted Republic Act number 11469, which declared a state of national emergency. It was Congress this time that declared a state of national emergency, which provided emergency powers that were necessary and proper for the president to meet the national emergency. Now, at this point, I wanted to share my observations regarding this this series of declarations. If you will notice, since the 1940s, there were only two instances that did not require the outright exercise of the commander-in-chief powers of the Constitution. The declared emergency necessitated in these two instances were either an economic or civil defense response in the following in these situations. First was the economic emergency in 1989 involving the Electric Power Crisis Act. And second, the public health emergency that we are now currently experiencing in order to address the global pandemic brought about by the coronavirus disease. Note that these were the only two instances that did not invoke the commander-in-chief powers. 12 out of 14 situations which we discussed involved the invocation of the commander-in-chief powers. Now let's look at the different categories of national emergencies. The first category involved national emergencies necessitating a military defense response. The second category involves national emergencies necessitating a civil defense response. And the third category involves a national emergency necessitating an economic response. If the economy is on the verge of collapse, certain extraordinary powers may be required if there is an economic recession looming, uh, um, that would arrest or address rather that would address the seeming need for an economic relief package. Now let's define these three categories. A civil defense or civil protection emergency contemplates measures to protect citizens of a state from catastrophes. The purpose of these measures is to save lives and to protect property, public welfare, public health, and safety, or to lessen or avert the threat of a catastrophe. It is a system of protective measures and emergency relief activities conducted by civilians in case of either natural disasters, such as pestilence, epidemics or pandemics, typhoons, floods, or other similar catastrophes. A military defense emergency is an emergency condition necessitating the use of military force, military defensive force that exists when a major attack is made upon the armed forces either through lawless violence, invasion, or rebellion, where the security of the state, including the lives of the people, are in danger. Finally, an economic emergency contemplates the situation where emergency measures are resorted to in order to avert an economic crisis and restore the stability of the national economy, prevent a recession, and avert widespread chaos and economic dislocation. May I call your attention to an important aspect of the law on national emergencies, judicial review. And it is important for both lawyers, law students, and aspiring lawyers to know the legal remedies that can be resorted to in court in order to vindicate or recognize rights. When it comes to judicial review, Article 8, Section 1 is the flagship provision to lay the constitutional basis for judicial review, especially when a branch or instrumentality of government commits an act that is tainted with grave abuse of discretion amounting to lack or excess of jurisdiction. This is known in Section 1 as the grave abuse clause. That is the second part of Article 8, Section 1. So the grave abuse clause must be read in relation to Article 6, Section 23, Paragraph 2 on the delegation of emergency powers by Congress to the President, as well as Article 7, Section 18 of the Constitution, involving the Commander-in-Chief powers in questioning the sufficiency of the factual basis of the suspension of the privilege of the writ of habeas corpus or the declaration of martial law. Likewise, the grave abuse clause may be used to, in relation to Article 12, Section 17, which involves the power of the state during national emergencies to temporarily take over or direct the operation of any privately owned public utility or business affected with public interest. Likewise, the grave abuse clause involves the protection of the Bill of Rights. Another provision that may be subject to judicial Araneta versus Dinglasan, the court Okay, let's continue. The ruling, however, in Montenegro versus Castañeda was overruled in Lansang versus Garcia. Lansang versus Garcia is a significant case. It is significant jurisprudence because the power of judicial review that the court, which the court discussed in Lansang versus Garcia, found its way into Article 7, Section 18 on the Commander-in-Chief powers, especially with respect to a review of the sufficiency of the factual basis for the declaration of martial law. But it should be noted that in Lansang versus Garcia, what was brought to the fore was the issue of whether the suspension of the privilege of the writ of habeas corpus by the president was is subject to judicial review. And so the Supreme Court here that the power to determine the sufficiency of the factual basis of the suspension of the privilege of the writ of habeas corpus is a justiciable question, which the court is empowered to determine. However, in the findings of the court in Lansang, although the ruling provided for judicial review on the determination of the factual basis, on the sufficiency of the factual basis for the suspension of the privilege of the writ of habeas corpus, the court eventually deemed the suspension to be not unconstitutional with respect to uh, um, the Plaza Miranda bombing. Now, in Lansang, this is what the court laid down. Article 7 of the Constitution vests in the executive the power to suspend the privilege of the writ of habeas corpus under specified conditions. Pursuant to the principle of separation of powers underlying our system of government, the executive is supreme within his own sphere. However, the separation of powers under the Constitution is not absolute. What is more, it goes hand in hand with a system of checks and balances, under which the executive is supreme as regards the suspension of the privilege, but only if and when he acts within the sphere allotted to him by the Constitution or the basic law. And the authority to determine whether or not he has acted is vested in the judicial department, which in this respect is in turn constitutionally supreme. In the exercise of such authority, the function of the court is merely to check in accordance with the system of checks and balances, and not to supplant the executive or to ascertain merely whether he had gone beyond the constitutional limits of his jurisdiction, not to exercise the power vested in him or to determine the wisdom of his act. To be sure, the power of the court to determine the validity of the contested proclamation is far from being identical to or even comparable with its power over ordinary civil or criminal cases, elevated thereto by ordinary appeal. Even comparable with its power over ordinary civil or criminal cases elevated thereto by ordinary appeal from inferior courts, in which cases the appellate court has all the powers of the court of origin. Lansang versus Garcia. The factual necessity of calling out the armed forces is something that is for the president to decide. He has a vast intelligence network to gather information, some of which may be classified as highly confidential or affecting the security of the state. In the exercise of the power to call out the armed forces, on-the-spot decisions may be imperatively necessary in emergency situations to avert great loss of human lives and mass destruction of property. Although the court, in a proper case, may look into the sufficiency of the factual basis of the exercise of this power, the calling out power, on the basis of its power to determine grave abuse of discretion, this is no longer feasible when the proclamation has already been lifted. Integrated Bar of the Philippines versus Zamora. It was rendered moot and academic because the president lifted that order calling out the armed forces. The court in a proper case may look into the sufficiency of the factual basis of the exercise of this power. However, this is no longer feasible at this time as Proclamation number 38 has been lifted in Lacson versus Perez. A state of rebellion was declared. But may I invite your attention to this case, San Lakas versus Executive Secretary, where Justice Tinga clearly laid down the doctrine of the Commander-in-Chief powers. Article 7, Section 18 grants the President as Commander-in-Chief a sequence of graduated powers, from the most to the least benign. These are the calling out power, the power to suspend the privilege of the writ of habeas corpus, and the power to declare martial law. In the exercise of the latter two powers, the Constitution requires the concurrence of two conditions, namely an actual invasion or rebellion, and that public safety requires the exercise of such power. However, as we observe in Integrated Bar of the Philippines versus Zamora, these conditions are not required in the exercise of the calling out power. The only criteria is that whenever it becomes necessary, the President may call the armed forces to prevent or suppress lawless violence, invasion, or rebellion. In all three instances, from the most to the least benign, from the prevention or suppression of lawless violence to invasion to rebellion, the power of judicial review may be exercised by the Supreme Court in determining the sufficiency of the factual basis for these, for the exercise of these powers. In calling out the armed forces, a declaration of a state of rebellion is an utter superfluity. These are the words of Justice Tinga speaking for the Supreme Court and back. The state of a declaration of a state of rebellion is an utter superfluity. At most, it only gives notice to the nation that such a state exists and that the armed forces may be called to prevent or suppress it. Perhaps the declaration may wreak emotional effects upon the perceived enemies of the state, even on the entire nation. But this court's mandate is to probe only into the legal consequences of the declaration. This court finds that such a declaration is devoid of any legal significance. For all intents and for all legal intents, the declaration is deemed not written. Now, we go to David versus Arroyo, which is instructive on the power of judicial review. In David versus Arroyo, there was a challenge as to the constitutionality of Presidential Proclamation number 1017. Presidential Proclamation number 1017 involved a declaration of a state of emergency. The Supreme Court held that Presidential Proclamation 1017 is constitutional insofar as it constitutes a call by President Arroyo on the armed forces of the Philippines to prevent or suppress lawless violence. However, the provisions of Presidential Proclamation 1017, commanding the armed forces of the Philippines to enforce obedience to all laws not related to lawless violence, as well as decrees promulgated by the president, are unconstitutional. The president, likewise, cannot take over privately owned public utility or business affected with public interest without prior legislation. Please note, ladies and gentlemen, that when we read Article 12, Section 17, the operative phrase there is the state. It is not the president. It is not Congress. It is Congress enacting an emergency powers law and delegating the execution or the implementation of the emergency powers to the president. So the power to grant emergency measures Congress, but is delegated to the president in so far as Article 12, Section 17 in relation to Article 6, Section 23, Paragraph 2 is concerned. It is clear that Presidential Proclamation 1017 is not a declaration of martial law. It is merely an exercise of President Arroyo's calling out power for the armed forces to assist her in preventing or suppressing lawless violence. President Arroyo could validly declare the existence of a state of national emergency, even in the absence of a congressional enactment. However, the exercise of emergency powers, such as the taking over of privately owned public utility or business affected, which requires a valid delegation of legislative power from Congress. Courts have often said that constitutional provisions in pare materia are to be construed together. Otherwise stated, different clauses, sections, and provisions of a constitution which relate to the same subject matter will be construed together and considered in the light of each other. Considering that Section 17 of Article 12 and Section 23 of Article 6 previously quoted relate to national emergencies, they must be read together to determine the limitation of the exercise of emergency powers. These emergency powers must always be narrowly tailored, especially if it violates the Bill of Rights, because then it would undergo the strict scrutiny test. Generally, Congress is the repository of emergency powers. This is evident in the tenor of Section 23, Paragraph 2, Article 6, authorizing it to delegate such powers to the president. Certainly, a body cannot delegate a power not reposed upon it. Now, this is the Youngstown case, which is in all fours with the taking over of a private business. In David versus Arroyo, it involved the Daily Tribune. In the Youngstown case, it involved, in April 1952, President Harry S. Truman issued an executive order directing the Secretary of Commerce, Charles Sawyer, to seize and operate most of the nation's steel mills. This was done in order to avert the expected effects of a strike by the United Steelworkers of America. The court held that the president did not have the authority to issue such an order. The court found that there was no congressional statute that authorized the president to take possession of private property. The court also held that the president's military power as commander-in-chief of the armed forces did not extend to labor disputes. The court argued that the president's power to see that the laws are faithfully executed refutes the idea that he is to be a lawmaker. Youngstown Sheet and Tube Company versus Sawyer. Now, of recent vintage is Lagman versus Medialdea, involving proclamation number 216. Proclamation number 216 was declared not unconstitutional on the ground that there was factual basis for the declaration, that there was a rebellion and public safety required it. In 2018, that threat still existed. So the rebellion still existed. So the extension of martial law under proclamation number 216 was questioned. The court ruled that the rebellion persisted as to satisfy the first condition for the extension of martial law or for the suspension of the privilege of the writ of habeas corpus. And public safety requires it under the second condition for the extension. Let's go back to the present day public health concerns, especially since the first quarter of 2020. Now, in my notes, I placed a factual timeline, but at this point, I will just summarize this timeline. So the timeline starts from December 2019 until the present, April 2020. Sometime December 12, 2019, the first people exhibited symptoms of a flu-like illness that was first identified in Wuhan, China. But at that point, little did everybody know that it would be a serious threat to public health beyond the borders of, in fact, even Wuhan. In fact, beyond the borders of that hospital. But it was on December 30, 2019, when the director of the emergency department of the Wuhan Central Hospital, Dr. Ai Fen, received some very disturbing medical reports involving a patient, which was labeled SARS coronavirus. Dr. Ai Fen was the first doctor to have ordered tests on these early coronavirus patients. Based on this report by Dr. I. Fen, another doctor, an ophthalmologist, Dr. Li Wenliang, was alarmed. And after reading the patient's report from Dr. I. Fen, who encircled the word SARS in her report, Dr. Li Wenliang warned colleagues about a new coronavirus strain via social media. In this case, from the WeChat platform. Dr. Ifen, in an interview, mentioned that she was not the whistleblower in this case. She identified herself as the person who gave the whistle, but not the whistleblower himself. It was Dr. Li Wenliang who informed his colleagues in the entire world of this new strain of the SARS coronavirus. By December 31st, China alerts the World Health Organization to this type of pneumonia-like symptoms of this respiratory disease. So flu-like cases came about. And there was an outbreak of pneumonia affecting dozens of patients in Wuhan. Chinese authorities, but on the last day of the year, treated many cases, dozens of cases of pneumonia, which was of unknown cause. The government in Wuhan confirmed that health authorities were treating dozens of cases. By January 1st, 2020, they traced this unknown virus to a seafood market in Wuhan. And so the Huanan seafood wholesale market in Wuhan was ordered closed by Chinese authorities on January 1st, 2020. By January 3rd, Chang Airport in Singapore began screening passengers who entered Singapore. It was the first. It was the first airport to do so. So temperature screening was made, thermal detectors to determine signs of illness. Now, from January 7th till the present, there was a progression of events, both from as it spread throughout the entire world, from Wuhan to other parts of China, to other parts of the world. And well, unfortunately, the Philippines earns the historical ignominy to have the first case of the disease within its shores, which was a 38-year-old Chinese woman. So in January 30, the first case outside China was in the Philippines. On that date, January 30th, the World Health Organization declared a global health emergency. So screening tests were conducted. But once again, another historical fact is that on February 2nd, the first death outside of China and the first death in the Philippines was recorded on the 2nd of February. The 38-year-old Chinese woman. But there were many cases. And so on March 9th, President Duterte formally declared a state of public health emergency and announced a partial lockdown, a community quarantine. Vice President Robredo likewise addressed the public about the coronavirus disease. Now, in the series of progressions from a general community quarantine to the present enhanced community quarantine, let me just two declarations were made: a state of public health emergency, as well as a state of calamity. In a state of calamity, what becomes operative here is that a state of calamity involves a natural disaster, and oftentimes in a state of calamity, it is the national disaster reduction risk, the national disaster risk reduction management, the national disaster risk reduction and management council that is called upon. But in this case, a state of public health emergency requires a public health response and an interagency task force for emerging infectious diseases was convened by the president. Now we spoke about Dr. Ifen on December 30th. By March 29th, she was reported missing in China. Now, extensions have been prevalent. There was an extension 2 weeks ago. However, let me just update everyone. Two laws were passed, one in 2019 and one earlier this year. The first law was Public Act number 11332, and the second law was Republic Act 11469. 11332 addresses a public health emergency, but additional powers were asked by the president to fully address the situation. Now we will get to 11469 in a few minutes. However, may I just update you on the recent events which transpired just today. The president just approved the extension of the enhanced community quarantine in selected regions, provinces, and cities nationwide until May 15, 2020. Now, let me just these were the high risk areas. Now, in what category, you may ask, in what category does a public health emergency belong to? A a national emergency due to public health concerns belongs in the category of a national emergency necessitating a civil defense response. Why does a public health emergency belong in this category, the category of a national emergency necessitating a civil defense response? A public health emergency, such as the coronavirus disease pandemic, necessitates the expertise of medical doctors and allied medical professionals, as well as public health authorities, preferably epidemiologists and infectious disease experts, as well as other specialists, as the lead agents in a national public health crisis, which now threatens the right to health of the people under Article 2, Section 15 of the Constitution. The government response has been threefold. First was the declaration of a state of public health emergency involving Presidential Proclamation number 922, which rendered operative Republic Act 11332, the declaration of a state of calamity under Presidential Proclamation number 929, and the enactment of Republic Act 11469, which is read in relation to Republic Act 11332. Now we have discussed the types of emergency powers. First, you have the commander-in-chief powers in case of invasion or rebellion when the public safety requires it. Then there is a declaration of a state of war, as in Araneta versus Dinglasan, which is a power reposed exclusively in Congress. Congress has the sole authority to declare a state of war. And another type of emergency powers involves the declaration of a state of emergency, which is exercised by the president upon prior authorization by Congress. Now, I just want you to look at these provisions, Article 6, Section 18, the Commander-in-Chief Clause. Now we have likewise discussed the graduated powers of the Commander-in-Chief Clause, the calling out power, the power to suspend the privilege of the writ of habeas corpus, and the martial law power. From the most to the least benign of powers as categorized by Justice Tina. Likewise, the constitutional basis of the declaration or of the granting of emergency powers is Article 6, Section 23, Paragraph 2. The power of Congress to declare a state of war is under Article 6, Section 23, Paragraph 1. We did likewise discussed Article 17, Article 12, rather, Section 17, involving in times of national emergency, when the public interest so requires, the state may, during the emergency and under reasonable terms prescribed by it, temporarily take over or direct the operation of any privately owned public utility or business affected with public interest. we cannot overemphasize the fact that emergency powers. Now let's look at Republic Act 11469, the Bayanihan to Heal as One Act, which I'd like to call the Emergency Powers Law 2020. It can come in the form of special powers or authorized powers, but just the same, the purpose of the law is to meet the existing public health emergency. Now, in my notes, I mentioned these these um, these laws, as well as pertinent provisions. I want you to have a look at those, but let me invite your attention to, well, aside from the declared national policy, let me invite your attention to the construction or interpretation of the law under Section 7 therein. Nothing in Republic Act number 11469 shall be construed as an impairment, restriction, or modification of the provisions of the Constitution. In case the exercise of the powers herein granted conflicts with other statutes, orders, rules, or regulations, the provisions of this act shall prevail. Note that consistent with Marbury versus Madison, if there is a conflict between the Constitution and a provision of law, it is the Constitution that prevails. But in addition to that, with respect to other laws, Republic Act number 11469 and its provisions would prevail with respect to other laws and not the Constitution. It's the Constitution that is the standard or the measure of how the emergency powers are defined, limited, and exercised. Now, Section 4 involves authorized powers. But let me just invite your attention further on certain comments which I have on this law. Generally, the law enjoys a presumption of constitutionality, rather. And in fact, the aim or the purpose of Republic Act 11469 in relation to Republic Act 1332 is to address public health concerns on this global pandemic. And therefore, emergency powers, the first order of the day would be to look at 11332 first and 11469. 11469, it would seem that one authorized power that will prove useful is perhaps doing away with public bidding in the procurement of protective personal equipment, as well as medical supplies, ventilators or respirators in order to expedite the process. So in terms of medical equipment, that is in dire need in the Philippines today, medical supplies, masks, other equipment, um, ventilators. Um, and so this would require extraordinary powers because under the normal course of events, this would undergo the government procurement law. But because of the exigencies of the moment, because of the emergency at hand, we need these supplies at the earliest possible time. And therefore, emergency powers can be exercised to obtain or procure these either in the form of donations or in the form of outright purchase. Now, at this time, let me just invite your attention to my comments on my further comments on Republic Act number 11469. I actually have very few comments on Republic Act number 11469. Um, in these times, well, these provisions are well-meaning. However, there are certain provisions that were not narrowly tailored. And so they are a cause for concern among lawyers, especially constitutional law professors. Now, with respect to Republic Act 11469, I made a two-part analysis of Section 6F, and this is what Section 6F states. Individuals or groups creating, perpetrating, or spreading false information regarding the coronavirus disease crisis on social media and other platforms, such information having no valid or beneficial effect on the population, and are clearly geared to promote chaos, panic, anarchy, fear, or confusion, and those participating in cyber incidents that make use or take advantage of current crisis situation to prey on the public through scams, phishing, fraudulent emails, or other similar acts. Now, the intention of Section 6F may be noble, but it was not narrowly tailored, and I will show you why. I divided it into two parts. First, involved false information, and the second, those participating in cyber events, cyber incidents rather, that make use or take advantage of the crisis situation to prey on the public through scams, phishing, fraudulent emails, or other similar acts. Now, for the first part, it involves false information. It would seem that a facial challenge for being constitutionally infirm is readily apparent on two grounds. First, involves the vagueness doctrine, and second, involves the overbreadth doctrine. It's both vague and overbroad, and I will explain why. The void for vagueness doctrine may be explained as follows. A statute or a provision thereof is void for vagueness and unenforceable if it is too vague for a person of average intelligence to understand or if a term cannot be strictly defined and is not defined anywhere in such a law. If an average person cannot generally determine what persons are regulated, what conduct is prohibited, or what punishment may be imposed. So it's not clear what constitutes false information. There's no definition of what false information is. It likewise suffers the infirmity of overbreadth. A law is overbroad if it substantially prohibits conduct protected by the Constitution, such as forms of protected speech. If you look at false information, it can fall within the realm of political speech, certain types of information that is given. Political speech, as we know in our studies of constitutional law, has the highest protection under Article 3, Section 4. Political speech, which is constitutionally protected speech, may be included in Section 6F on false information. Now, granting the law has nobody questions the law based on these facial challenges. Could it be that there is an as-applied challenge? In specific instances, Section 6F may be challenged if it violates Article 3, Section 4 in specific instances. Firstly, what constitutes false information regarding the COVID-19 crisis? Supposing if it's not regarding the COVID-19 crisis, if it's some other type of ailment. So if there is false information, there must be information that is genuine or information that is true. So is truth now a defense? Who determines whether the information has any valid or beneficial effect on the population? So it will now be subject to interpretation. So the law has to be narrowly tailored to be able to reflect what constitutes false information, especially regarding the COVID-19 crisis, and not just false information on anything. Now, clearly, when you look at it, the objectives are noble. Those types of information that promote chaos, panic, anarchy, fear, or confusion. Of course, that is the ideal to have information that is only truthful. But the language of the law is in this manner. That the false information that may be given are clearly geared to promote chaos, panic, anarchy, fear, or confusion. If it is not clearly geared to promote the aforementioned objectives, is good faith then a defense? Now, let's look at Republic Act number 11469, Section 6F, and Article 3, Section 4 of the Constitution on freedom of expression. Now, granting someone is charged under the first part of Section 6F, it must pass through the crucible of the clear and present danger test with respect to that information. Chavez versus Gonzalez. A governmental action that restricts freedom of speech of the press based on content is given the strictest scrutiny, with the government having the burden of overcoming the presumed constitutionality by the clear and present danger rule. This rule applies equally to all kinds of media, including broadcast media. During that time, 2008. So definitely in 2020, this now includes social media. So by analogy, Chavez versus Gonzalez will apply to social media. In a famous dissenting opinion of Justice Holmes in Abrams versus United States, in how he defined what a clear and present danger is. So the clear and present danger test is applied in this manner. The question in every case is whether the words used are in such circumstances and are of such a nature as to create a clear and present danger, that they will bring about the substantive evils that the Congress has a right to prevent. It is a question of proximity and degree. So if there is a clear and present danger when it comes to that type of information, then that speech or that information can be suppressed if there's a clear and present danger test, if there's a clear and present danger. Now, may I propose an additional test, which is a modification of the clear and present danger test. It is called the imminent lawless action test, exemplified in Brandenburg versus Ohio. In the imminent lawless action test, the US Supreme Court here held that the government cannot punish inflammatory speech unless that speech is directed to inciting or producing imminent lawless action and is likely to incite or produce such action. There are three elements of this test. There is an intent to speak, there is imminence of lawlessness or imminence of this action, and there is likelihood of lawlessness. So if the degree of imminence of that lawless action is apparent, it is justified to suppress that speech. But who determines it? There may be varying interpretations to that information. Some people may not even mind that sort of information. Others may take it seriously. But if men of average or people of average intelligence interpret the words, they must create either a clear and present danger or some kind of imminent lawless action. If in allowing that information to be circulated in social media were to be tolerated, if imminent lawless action is apparent, then it would be possible to suppress that speech. But it must pass the crucible of either the clear and present danger test or the imminent lawless action test. In a Philippine case, NVRS Publications Incorporated versus Islamic Dawah Council of the Philippines, the imminent lawless action test likewise of Brandenburg versus Ohio was discussed in this manner. Advocacy of illegal action becomes punishable only if such advocacy is directed to inciting or producing imminent lawless action and is likely to incite or produce action. Except in unusual instances, Brandenburg protects the advocacy of lawlessness as long as such speech is not translated into action. So if it's just a mere thought process, without any act, without any positive act, then there is no imminent lawless action. But if that thought is translated into action, then those words or the information that was placed on social media is punishable. Now, this is also, if if you will notice, um, if cases are filed in court based on Section 6F or some other statute involving false information or false news or cyber libel or libel, um, in many instances, the best remedy is to counter speech with other speech, to counter falsity with the truth. And this brings us to the counter speech doctrine. In the words of Justice Anthony Kennedy, a decision which best exemplifies the counter speech doctrine, uh, counter speech, counter bad. There is a there is a remedy of countering bad speech with good speech, of countering negative speech with positive speech. Thus, government should counter false speech with truthful speech, as opposed to engaging in raw censorship and stark oppression. In the words of Justice Anthony Kennedy in United States versus Alvarez, which best exemplifies the counter speech doctrine. The remedy for speech that is false is speech that is true. This is the ordinary course for a free society. The response to the unreasoned is the rational, to the uninformed, the enlightened, to the straight out lie, the simple truth. Justice Brandeis, in his concurring opinion in Whitney versus California, had this to say about enforcing the counter speech doctrine. If there be a time to expose through discussion the falsehood and fallacies, to avert the evil by the processes of education, the remedy to be applied is more speech, not enforced silence. Of course, this type of counter speech may be rendered operative if there is no clear and present danger, or if there is no imminent lawless action. So counter speech in ordinary cases may be resorted to, but only in cases where there is a clear and present danger and is not lawless action will that speech be punishable. Now, the second part involves cyber incidents through scams, phishing, fraudulent emails, or other similar acts. If you look through the law, those participating in cyber incidents that make use or take advantage of the current crisis situation to prey on the public through scams, phishing, fraudulent emails, or other similar acts. Now, in this case, there may be a possibility for a facial challenge on the ground of vagueness, because there's no definition of what are cyber incidents, what are scams, what is phishing, even if we do know it, what are fraudulent, what constitutes fraudulent emails. Law has to be narrowly tailored, and Section 6F suffers from these facial infirmities. But for this second part on cyber incidents, it is it suffers from being vague. If you will notice, Section 6F may be vague, but it is not overbroad. Why is it not overbroad? Because it limits commercial speech. And unlike political speech, commercial speech may have limited constitutional protection. Okay, let's now continue. We are now in the area of commercial speech. Commercial speech has limited constitutional protection, and I will show you why in the Hudson test. Commercial speech has limited constitutional protection and thus may be subject to government regulation. It is entitled to less protection than political speech and can be regulated if false or misleading. So Congress had the right idea here to limit commercial speech. However, it just needs to be narrowly tailored. There needs to be definitions on what are cyber incidents, what is phishing, what are fraudulent emails, and the like. At the outset, we must determine whether the expression is protected by the free speech clause. For commercial speech to come within that provision, it at least must concern lawful activity and not be misleading. Next, we ask whether the asserted governmental interest is substantial. If both inquiries yield positive answers, we must determine whether the regulation directly advances the governmental interest and the governmental interest asserted, and whether it is not more extensive than necessary to serve that interest. Central Hudson Gas and Electric Power Corporation versus Public Service Commission. Thus, the Central Hudson test presents the following questions for the court. Does the speech concern a lawful activity and is not misleading? If it meets these requirements, then there are other questions to answer. Does the government have a substantial interest? Does the regulation directly and materially advance the government's substantial interest? Is the regulation narrowly tailored? If the speech is fraudulent, illegal, and misleading, then it is not protected commercial speech. And the second part of Section 6F has the right idea. You punish commercial speech that is fraudulent, illegal, and misleading. In other words, people should not be allowed to profit from the miseries of others, from fraud, from an illegal act, from misleading the public on certain cures. But the question before us is this regulation narrowly tailored? So that is the question that you need to answer. Because if it is narrowly tailored, then you apply the law. And if the speech is fraudulent, illegal, and misleading, then it is not protected commercial speech. You can punish the person who sent the fraudulent email. The Central Hudson test involves intermediate scrutiny analysis, as the government only has to invoke a substantial government interest rather than a compelling governmental interest, as in a strict scrutiny analysis or commercial speech. Commercial speech not only includes the right of the speaker to speak, but also the right of the listener to receive information. Even if this type of speech is protected, it does not mean that it is immune from government regulation. Commercial speech is entitled to less protection than political speech and can be regulated if false or misleading. Unlike with political speech, the truth of which may be difficult to ascertain, the court thought commercial advertising to be more objective and thus subject to determination of its truth content. So you must distinguish whether the type of speech that was placed in social media or that cyber incident is within the realm of political speech or commercial speech. You have to make that distinction. Now, transfer of appropriations under Article 6, Section 25, Paragraph 5. With respect to the transfer of appropriations, this involves Araulio versus Aquino. It's just more of a guideline for the implementers of Republic Act number 11649, involving the transfer of appropriated funds. The transfer of appropriated funds to be valid under Section 25, Paragraph 5 must be made upon a concurrence of the following requisites. There is a law authorizing the President of the Senate, the Speaker of the House, the Chief Justice of the Supreme Court, and the heads of the Constitutional Commissions to transfer funds within their respective offices. So with the President, only with respect to the Executive Department. With the President of the Senate, only with respect to the Senate. With the Speaker of the House, only with respect to the House of Representatives. The Chief Justice within the judiciary, and the heads of the constitutional commissions within their respective constitutional commissions. Second, the funds to be transferred are savings generated from the appropriations for their respective offices. And third, the purpose of the transfer is to augment an item in the general appropriations law for their respective offices. Thus, cross-border transfers of the savings of the executive to augment appropriations of other offices outside the executive is unconstitutional in Araulio versus Aquino with respect to the disbursement acceleration program. The office of the President cannot allocate funds found within the executive department or within his office or within his purview to that of the Senate or the House of Representatives or to other constitutional commissions. The transfer of savings must be within the executive department. So cross-border transfers of funds are unconstitutional. And cross-border augmentations from savings are likewise prohibited by the Constitution. By providing the President of the Senate, the Speaker, the Chief Justice, and the Constitutional Commission heads the authority to augment any item in the GAA for their respective offices. Section 25, Paragraph 5 has delineated borders between their offices such that funds appropriated for one office are prohibited from crossing over to another office, even in the guise of augmentation of a deficient item or items. Thus, we call such transfers of funds cross-border transfers or cross-border augmentations. The phrase respective offices used in Section 25, Paragraph 5 refers to the entire executive with respect to the President, the Senate with respect to the Senate President, the House of Representatives with respect to the Speaker, the judiciary with respect to the Chief Justice, the constitutional commissions with respect to their respective chairpersons. Araulio versus Aquino. The next involves Republic Act number 11332, which is the Public Health Emergency Act, mandatory reporting of notifiable diseases and health events of public health concern. Pursuant to the policy under Article 2, Section 15 of the Constitution, involving the right to protect and promote the health of the people and instill health consciousness among them, Republic Act number 1332 was passed in 2019 expressly to address epidemic or pandemic emergencies. Now, declaration of the policy. Declaration of policy. Article 2, Section 15 is the policy of the state. The right to health of the people and to instill health consciousness among them. Now, may I call your attention to the second portion. The state also recognizes disease surveillance and response systems of the Department of Health and its local counterparts as the first line of defense to epidemics and health events of public health concern that pose risks to public health and security. So the first line of defense are the health officials, the doctors and the professionals, the public health authorities. They are the first line of defense because they have the expertise, the special expertise to deal with these kinds of public health emergencies, epidemics, and other health events of public health concern. Now, with respect to the objectives under Section 4, may I just point out the underscoring. I supplied the underscoring for first line of defense to emphasize the importance of our health authorities and our doctors, nurses, and other health officials in combating any type of epidemic or pandemic. So that is clear in the law, in its declaration of policy. Now, for Section 4, may I invite your attention to this portion, Section 4F, number 3 and number 4, quarantine and isolation and rapid containment and implementation of measures for disease prevention and control, and that is the basis for our general community quarantine and now the enhanced community quarantine. And another objective, to respect to the fullest extent possible the rights of the people to liberty, bodily integrity, and privacy while maintaining and preserving public health and security. Under this act, so the mandate involves rapid containment, quarantine and isolation, disease prevention and control measures, as well as response activities for events of public health concern. All personnel of the DOH and its local counterparts and all other individuals or entities involved in conducting disease surveillance and response activities shall respect to the fullest extent possible the rights of people to liberty, bodily integrity, and privacy while maintaining and preserving public health and security. So there are prohibited acts. Well, under Section 7, the President shall declare a state of public health emergency in the event of an epidemic of national and or international concern which threatens national security, in order to mobilize governmental and non-governmental agencies to respond to the threat. And clearly, Presidential Proclamation 922 affirms is an example of the operation of Section 7. Section 9 involves prohibited acts. So may I likewise call your attention to a certain type of prohibited act. So let's look at the disclosure of confidential information. Now, there are penalties. Now, let me just provide you with certain comments. On this law. Now, you'll notice a few days ago, there was this headline: government requires COVID-19 patients to disclose personal information to enhance contact tracing. Does not be an affront to a person's right to privacy, especially under the Data Privacy Act. If you will notice, Secretary Carlo Nograles explained it very well. What government will do is they will obtain a waiver. They will obtain a consent from patients in order to disclose personal information to enhance contact tracing. Contact tracing is important because we have to know the root of the virus. So if we can look at the root cause, we can develop a cure for this. And so Secretary Nograles explained it well. It's not exactly a violation of the data privacy law. There are exceptions, and I will explain to you what these exceptions are. Section 6G in relation to Section 9A and Section 9, Paragraph 2. All personnel, we already got this a while ago. They're first responders. So they are the first line of defense. But at the same time, there is a concomitant obligation to respect to the fullest extent possible the rights of people to liberty, bodily integrity, and privacy while maintaining and preserving public health and security. Prohibited acts, unauthorized disclosure of private and confidential information pertaining to a patient's medical condition or treatment. The disclosure of confidential information will not be considered a violation of this act under this section if the disclosure was made to comply with a legal order issued court of law with competent jurisdiction. Health and medical records are sacrosanct. They constitute sensitive personal information of a person. Health and medical records are protected by the Data Privacy Act, Republic Act 10173. Since they are sensitive personal information, they are protected by the data privacy law. Now, what can we do? Let's read Republic Act number 10173 in relation to Republic Act number 11332. To ensure the compliance with the Data Privacy Act, there are two remedies that may be pursued. One may obtain a lawful order of a court of law, or one may obtain the consent of the patient. This was what Secretary Nograles was saying. One may obtain the consent of the patient as the data subject to waive confidentiality on his health or medical records. So there are two remedies here, two exceptions that may exist in order to comply with both the Data Privacy Law and Republic Act 11332 on contact tracing. Now, please, that the first line of defense are our medical experts, our medical authorities, the doctors, the nurses, and allied medical professionals. But please note that in order for us to effectively address this global pandemic, to be able to strive for, well, in some areas, containment, in other areas, mitigation. It requires the grassroots network of our local government units. So the success of this requires the cooperation of both the national government and the local government units. So in this case, Republic Act number 7160, the local government code, especially section 105, provides certain powers to the Secretary of Health. Now, in this case, section 105 of the local government code may be invoked to provide direct national supervision and control by the Secretary of Health. Note that this is a special power granted to the Secretary of Health in cases of epidemics, pestilence, and other widespread public health concerns and dangers. The Secretary of Health, in this instance, may, upon the direction of the President and in consultation with the local government unit concerned, temporarily assume direct supervision and control over health operations in any local government unit for the duration of the emergency, but in no case exceeding a cumulative period of 6 months. With the concurrence of the government unit concerned, the period for such direct national control and supervision may be further extended. So if you will notice, to be able to address this national emergency, necessitating a civil defense response, it requires the cooperation of the national government, the local government units, and the first line defense in our medical fields, in the different medical fields. And so it is not just one person or group of persons, it is all of us. And in fact, we are contributing through putting this information out to ensure that government is successful in addressing this global pandemic at the earliest possible time. Now, oftentimes, well, the Constitution is called upon, as I mentioned at the start of this lecture, the Constitution is placed in a difficult situation, oftentimes, to provide a delicate balance between liberty and security. But if you read the law in its totality, there is no conflict between liberty and security. They are part of the greater whole to preserve the state. The state, which has four elements: people, territory, sovereignty, and government. And in that sense, the Bill of Rights, the Constitution of Liberty, and the Constitution of Government go hand in hand in providing for a stronger state structure. Now, to recap our lecture for today, I provided it in your notes. I divided it into constitutional provisions, presidential proclamations, statutes passed by Congress, as well as Supreme Court jurisprudence. So by way of summary, let's look at in order to address, or in studying the law dealing with national emergencies due to public health concerns, you need to look at Article 2, Section 15, Article 6, Section 23, Paragraph 2, Article 6, Section 25, Paragraph 5, Commander-in-Chief clause under Section 18 of Article 7, the power of the state during national emergencies to temporarily take over or direct operation of any privately owned business under Article 12, Section 17, the power of general supervision over local governments by the President under Article 10, Section 4, the Bill of Rights, the Grave Abuse Clause under Article 8, Section 1, as well as Article 10, Sections 2 and 3, and Section 5, involving local autonomy and decentralization of administration of local government units. Now, for purposes of the COVID-19 crisis, you may look at Presidential Proclamation 922 and Presidential Proclamation 929. With respect to statutes passed by Congress, the two that I mentioned, Republic Act 11469, Republic Act 11332, the Local Government Code, as well as the Data Privacy Act. As for cases, just to summarize, Araneta versus Dinglasan, Lansang versus Garcia, Integrated Bar of the Philippines versus Zamora, Lacson versus Perez, San Lakas versus Executive Secretary, David versus Arroyo, Youngstown Sheet and Tube Company versus Sawyer, and Araulio versus Aquino. I will be happy to answer any of your questions if you have any. And thank you for your time, for listening. So one additional thing, well, I hope everybody is doing fine. Please stay safe and healthy, and hopefully we will be back studying the law firsthand fairly soon. So, if would you have any questions? I'll be happy to answer any of the questions. Yes, there is a question here. The LGUs are imposing their own community quarantine and enhanced community quarantine measures through an executive order. Is this valid? Is an ordinance the appropriate action? Of course, ordinances are always strengthens the legal basis. But under the circumstances, what governs our situation involves the application of Republic Act number 11649 in relation to Republic Act 11332. What may perhaps be apparent here is that local government units are enforcing the community quarantine and enhanced community quarantine of those of Republic Act 11332. That in itself is the legal basis. So the legal basis is Republic Act 11332, as well as its implementing rules and regulations. Now, with respect to other types of incidents, um, ordinances are the proper vehicle to effect specific types of measures in a community. But essentially, Republic Act 11332 already covers it in relation to Republic Act 11469. Now, um, of course, when it comes to the penalties, the reason why ordinances are are should be passed is that there are specific penalties imposed by the laws provided by Congress. But when it comes to the implementation on the local level, there may be some some disparity from the penalties imposed by the national laws, because what the local chief executives are imposing are in fact the national law, which is passed by Congress, that emergency as directed or as provided for by the president. Remember, it is the president here who has a direct hand in imposing this quarantine. Um, the executive order is merely a manifestation of that. But if the local sanggunians pass an ordinance, it would be clearer with respect to certain violations, because there may be violations that have imprisonment for 1 week or overnight, or there is no uniform. There is no uniform implementation of the penalty, and an ordinance can address that to at least make it uniform for that local government unit. Now, with respect to curfews, well, what is instructive here is Spark versus City of or versus Quezon City, Navotas, and Manila. In Spark, it requires a local ordinance unless it is imposed on a national level as part of the quarantine. But to add strength, to add clear legal basis from the standpoint of the local government units, an ordinance providing for a limitation on the number of hours, a number of hours out in order to prevent the spread of the virus may be possible under an ordinance. The legal basis in will be Act 11332 in relation to Republic Act 11649. Is there any other question? Let's check. maybe another 5 minutes uh, to entertain questions. If there are any other questions, well, you can send it through the Philippine Association of Law Schools um, messenger thread, and we will be happy to answer your questions. Um, of course, we live in uncertain times, and in these uh, in these times, well, um, it's best to get the right type of information in order to make informed decisions, whether it is a medical matter or uh, a legal matter. Um, I guess at this time, if there are no other questions, may I thank all of you viewers for listening this afternoon. I hope that this lecture uh, puts into perspective um, the need to be uh, more critical and more discerning with the way we view the law. Uh, it's important that um, lawyers and law students um, are able to look at the finer points of the law, and that is the purpose of this PALS lecture series, to be able to prepare you for the practice of law. And for those that listen who are not law students, um, well, thank you for listening. I hope the information was also useful to you. Um, so our next speaker uh, will be next week. I think it will be Dean Nilo Divina of the UST Faculty of Civil Law, who is um, one of the foremost experts in the corporation code. So you will have an excellent lecture next week. Um, thank you once again, and well, uh, let's keep the conversation going, whether in PALS or in social media. Stay safe and healthy, and we hope to see you all soon. Thank you and a pleasant good afternoon to all.